Good afternoon, everyone. This is Attorney Elise Gross, the Presser Law Firm. Just want to go over a couple of housekeeping details before we get started. Number one, if anyone gets disconnected, we've posted the call-in number on the bottom so that you can get back in. If you've got any questions during the webinar, please email them to info@assetprotectionattorneys.com. We're going to do some Q&A at the end, and hopefully we'll get questions. If you get disconnected and can't get in by phone, you can email and we'll try to get you back in. In addition, if anyone is interested and they have not already signed up for our weekly newsletter, we'd be happy to make sure to get you on the list. We have complimentary preliminary consultations for anyone who's interested in any legal topic. If you've got any questions, we're happy to speak with you. In addition to that, we have speaking engagements. All the attorneys in the firm are able to come speak with you depending on what topic you're looking at. If you have a group of people who desires to have some sort of education, please give us a call or contact us via email and we'll try to set that up for you if it can be worked out. Today we're going to be talking about protecting retirement assets. Overview of what we're going to talk about today. We're going to protecting your retirement accounts, rolling over your 401k into other retirement assets, the state protections that you can be afforded with retirement assets, using LLCs to protect your retirement, protecting the proceeds, and IRAs and how they relate to bankruptcy. Asset protection is how you own your assets so that they're titled in such a way that for the majority you can still control them, but they're out of the reach of future potential creditors. And it doesn't matter how much you have in the way of assets. No matter what you have, you've worked hard for and want to protect it. So there's no threshold in terms of a number. It's just a question of, do you have the desire to protect, in which case you should definitely seek professional advice from an attorney who specializes in that field, so that you know how best to protect those assets and what, if anything, is already protected under your state law. If you've already got an existing asset protection plan, which is not common, but there are people out there who have existing plans, then that asset protection plan may or may not be up to date in terms of what's the most beneficial way of owning assets. So you should always just have that reviewed, just like you would have an estate plan reviewed. You want to have your asset protection plan reviewed either on an annual basis or every time there's a big change in your financial picture and your marital status. If you inherit some money, if you have some sort of pending situations with your business, even new businesses, all that stuff needs to be looked at. And even if you have that asset protection plan, it doesn't mean you don't need to have some updates done. There's over 100 million lawsuits each year, and that number continues to grow, with a 1 in 4 chance that you'll be sued within the next year, with an average of 5 lawsuits over your lifetime. Now, those are some pretty high statistics. That's why it's important to make sure that the way you own your assets is the most beneficial to you and to your family. So it's not just estate planning, which is how do I leave those assets at my death, but it's how do I own it today, so that if I have a creditor, they can't get at it. Now, mind you, we're still talking about future potential creditors. Existing creditors are a whole other situation, and each case needs to be looked at individually to see if you can protect some of your money when you have an existing creditor. There's also a 50% chance of divorce. That number is growing. Asset protection can be used to shield some assets. Divorce, you're looking at the family law situation, family law court, but you're going to be governed by there. But in the event that you see something on the horizon, it's always a good idea to at least evaluate what your situation is. And of course, you can use a prenuptial or a postnuptial as part of potential future divorce planning. It doesn't really matter whether you win or lose a lawsuit. And that's something a lot of people don't understand. If somebody sues you, you're going to have to pay to defend it, and sometimes to just make it go away, even if there's absolutely no fault of your own, it's going to cost you out of pocket thousands of dollars, if not more, to make the lawsuit go away, just so you're not paying legal fees and just so you can sleep at night and not have to worry about it and move on with your life. So it doesn't really matter, again, who's at fault, because if somebody sues you, especially in states that are very litigious, it's going to end up costing you a great deal of money. Liability insurance is great. We very much advocate it. In fact, almost all types of insurance we advocate. However, it's a first line of defense. It's not the be-all, end-all. That's why you should have insurance, but you should have that insurance in conjunction with a proper asset protection and estate plan. So that, if somebody sues you, the first thing they're going to look at is the insurance, which may or may not cover that risk. And if it doesn't, you've got your backup plan, which is, your well-played asset protection plan. There are things that insurance companies don't cover, so you need to make sure that you're covered in some other way from that, like divorce or certain uninsured financial risks. Your insurance company can go bankrupt. That's something that never would have happened 20 years ago, but it did happen in the last 10 years. So it's something, it's not necessarily a common thing, but it can happen. So you've been paying for that insurance for a long period of time, then the company goes bankrupt, the government could bail out, the government may not bail out. You don't really want to be in that situation. So you shouldn't rely solely upon insurance. You always want to protect yourself before you have a problem. It's much more difficult for you to protect yourself after. So the best asset protection is proactive planning. You got to go see somebody, have them evaluate your assets, and make some plans for you that you implement and continue to obey the structure once it's set up, so that, God forbid, you do have a problem, you've been set up in advance as a proactive planner, and your chance of it protecting you are much greater. You don't have to start with some elaborate plan. All you need to do is start with the basic plan of what you need for your specific assets. And then what you do is you build upon that. So if something new comes into your life, whether it's a change of financial position, a new business, a new piece of property, you add on to your basic plan. So you've already got a good, stable first line of defense, and then you just add firewalls along with it. And not every plan is going to be the same. You have to look at everybody's individual assets, what they're trying to accomplish before you establish that right plan. So don't go looking up on the internet and saying, oh, I know exactly what I need to do. We've had many people who do that, and sometimes they have some decent ideas, but they're not trained to put it all together and make sure that it all works and make sure the implementation goes through in order to maximize the protection. Some of the things you absolutely must avoid. Number one, it's not about hiding your assets. Anytime somebody calls and says the word hide, I always correct them immediately. We don't deal in hiding assets. You're never going to really hide your assets. You can get some privacy, some anonymity from anyone but the IRS, but you're never going to be hiding anything. You always have to assume if somebody sues you that there's going to be full transparency, that they're going to know what you have because you're going to be under oath and have to give them documents and answer questions. So the best plans are the ones that really it doesn't matter what you have to tell them because you're still protected. You don't want to title your assets to who we call straws. That means it's not you. You find some friendly person or relative who's willing to own the assets for you, therefore it's not in your name. So if somebody sues you, well, they can't get at it. On the face, that sounds like a very good plan. The problem is that what happens if somebody sues that other person? They're the legal owner of the property. What happens if you have a fallout with said person? Then they say, oh, well, it's mine, it's not yours, you'll never see that again. Or if that person gets divorced, it could be part of their divorce. Or if they pass away, it's still going to be a problem because you don't own it. They have to plan for that in their estate planning. So that's not a really good plan. And in the same line, it's the same thing with titling stuff to your spouse. We used to see doctors who used to title all the assets to the spouse and used to think they have great asset protection. Well, the problem is their spouses drive cars, their spouses have potential liabilities, and then if the spouse gets sued, well, there goes the doctor's money. In addition to that, if there's a divorce, well, it's great for the spouse because they've already got all the assets, so they're in the driver's seat. And now you want them back. And you have to explain, well, why they weren't in your name in the first place and seek to get them back. So it's certainly not the best way to handle an asset protection plan. There are much better ways to handle it. Above all, you never want to break laws or commit fraudulent transfers. Breaking laws is easy. If it's criminal, there's going to be a statute. You can't violate the criminal statute in order to do any sort of protection. So you absolutely have to avoid that. Fraudulent transfers are actually civil. It's not a criminal act. And essentially what that means is if you transfer assets out of your name with the intent of not being able to pay your creditor, and it's depending on the state law, whether it's an existing creditor, a future creditor, a foreseeable creditor, there's different language depending on what state law, then technically that's a fraudulent transfer. And a creditor can come in and tell the court it's a fraudulent transfer, and potentially if they win, the court would be able to unwind that transfer. Now keep in mind, that usually doesn't happen until the creditor has a judgment against you. And what a lot of people don't realize is that generally the creditor doesn't know what you have until they actually get that judgment. Because with the exception of very few cases, they're not allowed to ask what you have until they've already gone to judgment. And it's then that they can put you under oath and ask you all these questions. So there's usually a lot of time between, oh, I may get sued, and the fact that a creditor has a judgment. But again, start way before that. Get your plan in place before that's even a possibility. Talking about retirement plans. ERISA qualified plans, those are federally done plans where the law protects the employees in that benefit plan that's sponsored. Usually it's employers or it's unions. Those plans have much better protection under the law than non-ERISA qualified plans. Some of these plans might be pension plans, 401ks, IRAs, certain other benefit plans, not straight retirement where you say, oh, I have a retirement, but you really have a bank account that you put away for retirement. That's not a qualified plan. The one thing you need to understand is while ERISA plans are generally protected in many states, there are certain things that they are not protected against. Federal tax claims, so if you owe the IRS for anything, they can get you anywhere they look. Federal criminal fines and restitution orders, so if you've committed a crime and you've been ordered to pay restitution, which means compensation to the people you've hurt, those are not. The ERISA plans won't be protected against that. Child support payments, alimony payments, and forfeiture if a court, applies forfeiture against any of your assets, those are not going to be protected. And just another little tidbit about asset protection. Child support payments and alimony payments in most situations rarely get protection with asset protection, which means that if somebody has a child support claim against you or alimony, it doesn't really matter what asset protection plan you have. The court will probably be able to get past that and order you to pay. International might be a little bit different, but on a domestic side, anything you do within the U.S., you need to keep that in mind because that could come up if you're in a family law or divorce situation. And then criminal or civil judgments, that's pretty broad. Criminal judgments, ERISA is not going to protect you from. A civil judgment, that's really going to depend on your state law of whether the ERISA plans are going to be protected under state law. Like in Florida, they're going to be protected. In other states, they may not be protected. Non-qualified plans, those are the non-ERISA qualified plans. And mind you, if they're going to be ERISA qualified, they have to fit into the certain governmental rules. And that's how they get to be ERISA qualified. And because they have more rules and because they have more standards, that's why they lack lawsuit protection. So for the most part, non-qualified plans are not protected. There are some places where they are, but you have to assume that a non-qualified plan is not protected. You got to look at the state law for that. Before I go any further, I think it probably behooves us to just kind of go over what different types of retirement plans there are so that we have a better idea of what we're talking about here. Pension plans, those are usually, if you work for the government, you usually see a pension plan. You don't usually see 401ks or IRAs or anything like that. Whereas if you have a private corporation or a private business, those usually have something in terms of a 401k plan where the individual can contribute to it and sometimes the employer will match it. Profit sharing plan, that's based on what the company's profits are. Do the employees get to share in those profits of the company? Traditional IRAs, that's obviously the most, used to be the most common. The Roth IRAs are taking over that. But the traditional IRA is with pre-tax dollars, which means that you put the money in, you potentially get a deduction for it, but then you end up paying taxes when you withdraw it once you reach the retirement age, which, by the way, is you can start taking retirement at 59.5. You must start taking your retirement at 70.5. So there's a window of opportunity there. If you don't need it, if you're still working, as most people are nowadays, then you can put off taking that retirement until you're 70.5. But at that point, once you're 70.5, you're actually required, no matter how much income you make from whatever job or investments you have, you must start taking what they call a required minimum distribution, or an RMD, every year from your retirement. Otherwise, there's big penalties for it. But when you take it out of a traditional IRA, or we'll talk about a SEP IRA or simple IRA, all those are pre-tax, which means you're going to pay tax at whatever your tax bracket is at that time. Let's contrast that with the Roth IRA. The Roth IRA is after tax. So you've already paid the tax on that. You put that money into your Roth IRA. When you retire, you do not have to pay taxes on that money because you've already paid the taxes. So that's becoming more and more popular. Sometimes, we'll talk about it in a little bit, people will roll over regular IRAs into the Roth. And that's just becoming popular because people are kind of scared of what, the taxes are going to be. Returning back to what we were talking about in terms of protecting the assets that you have in retirement. If you have extra cash and you are within your limits of what you can contribute to your retirement plans, and you're in a state where they're protected, then it's not a bad plan to use that extra cash to put into your retirement. You can always get it out of your retirement. You will pay heavy penalties if it's before you're of age. But if you put it in there and it's protected, at least you know it's protected. Again, if that's the only extra cash you have and you're going to rely upon that as, a safe place to put some savings, which you may need soon, that's not the best place to put it. You'd only put it there if it's something you really don't anticipate needing. Since the retirement plans are generally lawsuit-proof, again with those exceptions we talked about earlier, then you can invest your money in there and let it grow inside of the retirement plan. Because if it grows inside the retirement plan, then it's just more money for you to take out when you retire versus having it as in your personal name, completely unprotected, and you're just, paying the income tax now on whatever it earns. Once you reach the tax-deferred annual contribution to your retirement plan, so that's the maximum that you're allowed to put in. Mind you, there's a lot of different options depending on what kind of retirement plan you're using. Then what you want to do is pay some taxes and then put it in some other vehicle, whether it's a limited partnership, an international trust. We're going to be talking about that in a moment. You can take that unprotected cash, and if you can't get it into your retirement, pay some taxes on it and put it in some other vehicle. Some of those protected entities we talked about, you can actually use some of those in conjunction with your IRA. So for instance, let's say you've got your IRA and you want to invest in a piece of property. If you took that investment and put it in your personal name, then it's potentially accessible by creditors. If you set up an LLC in your personal name, then you hope to be in a jurisdiction where they do have what's called charging order protection for the LLC, so that a creditor could only get at distributions that you might take from the LLC. But let's say you want the growth of that property. You're hoping it's going to appreciate. You want to put it in your IRA so that that's more money for you to get when you retire. Well, you can't have your IRA directly own real estate, but what you can do is have your IRA actually set up an LLC and have the LLC own the real estate. So then you get both asset protection, you get growth within your IRA, and hopefully if you've been saving up money in your retirement, that gives you more buying power to buy the property that you might not otherwise have in your personal name. And that's becoming very popular. And you have to make sure that you go to the right people to set them up, because there's very important provisions that have to be in all the documents, because the IRA has special laws, special governmental laws, and you must be compliant with all of them. So don't just go setting it up yourself. Make sure that you are in contact with the IRA administrator and somebody who actually knows what they're doing before you set that up, because that could if it's done wrong, it could end up being a withdrawal from the IRA and have a heavy, heavy penalty. You can have your IRA held internationally. That's becoming more common as well. The advantage there is no one would be able to get to it, or very minute chance of that. In addition to that, it may give better investments or different investment opportunities internationally than you would have domestically. You can also have retirement accounts potentially owned by a foreign trust. That's a much more complicated situation, which you'd want to evaluate individually based on your circumstance. And I certainly welcome you to give us a call and we can discuss that in greater detail. But that is definitely a possibility if you're considering, moving things internationally. Another thing I want to talk about in terms of IRAs is how you leave your IRAs when you pass. IRAs can be left to individuals. They can also be left to trusts, but only if those trusts have certain provisions. So that's why, if that is even a possibility, you need to make sure that your estate planning attorney and your asset protection attorney, if it's a foreign trust for asset protection purposes, are fully aware of the rules and who the beneficiaries are going to be, because it will make a difference. Generally, from an estate planning perspective, we don't really encourage leaving the IRAs to trusts because there are potential tax consequences. There are times where it's a good idea depending on the ages of the beneficiaries, but you want to make sure that whoever you use is going to know exactly what they're doing in terms of that, because if that's messed up, then again, there could be huge tax consequences to the beneficiaries. When the IRA really has to be looked at, well, really not just the IRA, but all retirement plans have to be looked at in two ways. Number one, is it protected while it's actually in the retirement account? That's number one. The other nuance is what happens actually need to take the money out. Now you're over 59 and a half, or absolutely after 70 and a half. Now you've got to actually remove the money from the retirement account. That is a different story. We call that either the withdrawals or the proceeds. In some jurisdiction, those are protected. They may not be fully protected, but they can be protected up to a certain amount, but not in every jurisdiction. So you may have a jurisdiction where it's protected in terms of while it's sitting in there. So as I get older, my assets, I keep putting them into a retirement account. Somebody comes along and they want to get them. They can't get them because it's in a protected retirement account. But now I'm turning to the age where I have to start taking money. And once I start taking the money, well then, if it's not protected, those are individual assets, and they have to be protected some other ways. So you might consider, putting that in an annuity. You might consider putting it in your homestead if you're in Florida or Texas, or a state that has a good homestead law. With the exception of Florida and Texas, most states have a not great homestead law. Some are none, some are 5,000, some, are 100, 150. With the price of today's real estate, that's not really giving you great protection. So that may not be the best place to put it depending on where you're living. You can take that retirement, the withdrawal you have that's not protected, flip it around, as I said, into the annuity and homestead. You can put it in an international trust. You might consider putting it in a limited partnership. Many of our clients set up limited partnerships, put assets into it, and then know that when they start taking retirement, if they're not going to need that money, they're required to take it. So the limited partnership is a safe place to put it. So people are usually prepared. If they know they're retiring and they know they're going to have excess that they don't need, that's a good place to camp it. You don't want to get involved in a fraudulent conversion. Fraudulent conversions are different than fraudulent transfers. Fraudulent transfers, we talked about, are if you transfer assets out of your name and now you're unable to pay your creditors, that's a fraudulent transfer. A fraudulent conversion is where you take assets that were not exempt, cash in the bank, and then you put it in something that is when you have a creditor. So if you have no creditor, you can do whatever you want. If you have a creditor, then it's potentially going to be called back as a fraudulent conversion. Again, we're not talking about criminal in most cases, but depending on what you've done and where you've done it, it can be called a criminal act. So you need to be very careful about what you do. And again, the best planners are the ones who do it proactively before you ever have a problem, so these things cannot be called back against you. You have to always look, no matter what you're doing in the law, you've got to look at the statute of limitations. And the statute of limitations is how long does a creditor have to come after you, either to file a lawsuit against you or if they get a judgment against you to collect on that judgment. So be wary of that. If you think you have a claim, potential claim, know how long that creditor has to bring the action. If they've brought the action and they finally do get a judgment against you, judgments could be good for 20 years. So you have to be very careful of what assets you're getting, because those are potentially reachable by the creditors. There's also the statute of limitations in which to challenge a fraudulent transfer. So what that means is that the creditor can say, okay, I have this judgment. I want to look back, say a year, 3 years, 4 years, whatever the state law is on the statute of limitations to claim a fraudulent transfer. And the creditor can say, I have a valid judgment, and the debtor made a transfer within a certain period of time, and I'm within my right at this point to claim that it's a fraudulent transfer. And the judge may have to make you retract that transfer and reverse it. So it's not just that that judgment is still good. They have to have a proper time frame in order to claim the fraudulent transfer. So if anything that you're doing in terms of transferring assets should always be done before you ever have a problem. That way there's never going to be a fraudulent transfer claim, and even if there is, statute of limitations would have run. 4 years is the general standard. And then, as with any legal remedy, there's also that little catch-all of 1 year after the actual discovery of the transfer. So if you have discovered it, if the creditor discovered it, let's say in year 2, and it could be shown that they discovered it in year 2 and they waited until year 4, potentially you can get that thrown out. And then finally, we should just touch upon bankruptcy. When you're talking about asset protection, there's regular creditors and then there's bankruptcy creditors. Understanding that bankruptcy is a federal law. So even if a state protects things, if you're under federal bankruptcy laws and your state in some case can trump the federal law, you have to know all the rules and you have to know all the exemptions, both under federal and under state. That's why a lot of people come to Florida. We have some really good state laws, and the federal law says let's look to the state law. Some state laws say let's just go back and look at the federal law, but in Florida your state law is going to trump your bankruptcy laws, so that's why we're in a really good state. Let me give you an example of how they differ in Florida. Number 1 is homestead. Florida protects the homestead. If you move into a house, you declare it your homestead, it's where you live with the intent to remain for more than 180 days a year, then absent bankruptcy, your home is completely protected under the Florida homestead, which means no creditor can get at it unless they are your mortgage company, property tax collector, IRS, your homeowners or condo association, anyone who's done work on your house that you haven't paid, mechanics lien. Those creditors can get at it, but no one else would be able to get at it from day 1. In a bankruptcy situation, it changes a bit. And what that means is that you have to own and have that home as your homestead for 40 months before it's completely protected. Prior to that, every individual has a smaller exemption that there's protection against, but it's not much equity. It's about I forgot what number we're up to. It's about $150,000 individually, and with husband and wife, it's combined. So if you buy your house today for the next 40 months, if somebody puts you into bankruptcy or if you have to declare bankruptcy, your homestead is not completely protected. So you may want to keep your equity low at the beginning until you're completely protected. But then it won't matter if it's $10 million, $20 million, whatever your house is worth, it'll be protected except from those things that I told you about. So what a lot of people will do is once the time period is over, or if they think there's really no chance of any creditor ever pushing them into bankruptcy or they're declaring bankruptcy on their own, they will invest a lot of money into the home because they know it's protected. And even better, if your home is protected and you sell your home, as long as you do things properly and put the money into a segregated homestead account, which is really a bank account that says homestead proceeds, and if it's done properly and you reinvest that money in a new homestead within, say, 6 months or less, then you're still protected. So you have to, pay attention to all these things, know your rules, because they can really work for you. And then the statute of limitations isn't really going to apply. Some remedies that creditors have, number 1, if there's a fraudulent transfer, then if the creditor proves it, then what happens is they can potentially unwind your transfer, which means that if you had a house and you put it into an LLC and the creditor can show that it was a fraudulent transfer when it was done, then the court can say either they can make the LLC deed the property back to the individual, or they can force the LLC potentially to deed the property over to the creditor. In strong situations, the creditor can actually put a freeze on your assets. Now, we've seen this in rare occasions where in certain situations a creditor can actually freeze the assets during the lawsuit. It does happen. So you need to make sure that you've kept abreast of that. The creditor can get damages against the person who you've transferred it to, and then maybe against you. So before you start transferring things to somebody, you want to be wary of who they are and are they prepared for a fight if it ever comes back to haunt you. because they may get called into court and have to deal with, defending this, paying for, legal fees and things of that nature. So be very careful if you're, transferring any assets to someone else. And then if the creditor can prove, fraudulent transfer or there's judgment against you and you sold something, even if they can't unwind the transfer, they may be able to recover some of the proceeds that you got from that transfer. So be wary, of course, of the creditor's remedies, because those are going to apply whether it's, to your retirement accounts if they're vulnerable or really to any other assets. The way you avoid fraudulent transfers, obviously going back to the beginning, protect yourself before you have a problem. If you do proactive planning, then who's going to complain that you did a fraudulent transfer? And even if they do complain, generally the judge is not going to side with them. The judge will side with the debtor. You don't want to put too many eggs in one basket. That's a general rule of thumb for everything in life. So don't transfer too much to one person or one entity. So that might be, whether it's an LLC or it's a limited partnership or it's an irrevocable trust. Don't put it all in one place, because that just gives one bigger target. You spread out the targets. It makes it much harder for a creditor to go after you, and it puts you in a better negotiating position. But insider transactions, don't do too much between the family. Try to use third parties. It always looks better if there's third parties and there's consideration involved. Consideration is where you don't just give someone something, where you've received something valuable in return. You want to verify the value of your property. If you're going to transfer something, it's always a good idea to have some sort of documents that authenticate what it was actually worth. So even if a creditor can unwind or come after you and claim you did something wrong in terms of transferring the property, they're of course going to claim it's worth a lot more than you claim. If you have some sort of authentication, you're going to be in a much bigger position than you would have been before. And then of course, again, we said this before, you don't want to hide anything. If you hide things, that upsets a judge and just makes things more complicated. You want the judge on your side. So you don't want to ever hide anything. In addition to that, if they put you under oath, you're going to tell the truth because you can't perjure yourself. So hiding will have done you no good. So always assume you're going to have complete transparency, and just if you plan well, then it won't really matter. What we're going to do now is you're going to have a few minutes. We're going to gather the questions so we can have a question and answer period. There's going to be a poll. We wouldn't mind you answering, and it'll just take a moment of your time just to know that got our information across. And we'll come back in about 3 minutes or so. Okay, let's go over some of the questions that we just had. Number one, it disappeared. Okay, are Florida land trusts a good asset protection strategy for investment properties? And also, would a judge possibly view this as an attempt to hide assets? So the Florida land trust on its own is not a great asset protection strategy because someone could still sue the land trust and potentially get the property. It does provide privacy. There is a way to combine the land trust with an LLC so that the LLC is the beneficiary rather than an individual. Then you have the privacy along with the asset protection. In terms of whether that would anger a judge, you know, anything you do that a judge is going to find distasteful is, you know, going to be a problem. I don't really see where the judge would really have a problem with the land trust unless, you know, you did it at the last possible second, in which case you've got a fraudulent transfer situation, and then, yes, I could see a judge being upset by it. Next question we have are all monies in retirement plans protected in the case of a lawsuit? Is it protected from all creditors? Likely not the IRS. The IRS is a super creditor. You got to assume you're never protected from the IRS. This question came from somebody in Minnesota, and retirement accounts in Minnesota are very limited. They're only limited to $66,000. So that's for ERISA, and for IRAs it's $69,000. So in that situation, you're really not going to have great protection in Minnesota, in which case you might want to consider protecting your assets in another way and not dumping it all into retirement, or putting in retirement with, you know, using an international structure, maybe using an LLC to own some real property, but then when it comes out, there might be a problem. So I think we would want to discuss that further with you, whoever's asking that question, because I think that there's, you know, some potential there, but you really, based on your state law, are not getting great protection. We're going to do one more question. Does bankruptcy change my retirement plan's protection? And the answer is, depending on your state, is whether or not, you know, your retirement plans are going to be protected if your states don't defer to federal law. So you've got definitely some good protection, but it all comes back to what your state law says. I want to thank everybody for participating.